Welcome, welcome. What's going on? Welcome in. Let's see. We'll get some more people in a minute. What's going on, John? What's going on, Mike? Welcome in. Welcome in. Equity land, shoot. You always got to deal with stuff until you get out. Until you're out, you're still in. But it's better to be dealing in equity than it is at law. That's for sure. Absolutely. Hey, yo. Yeah. Equity is like a counterattack. You're not making the first move, but you sure as heck will have the last. Especially like dealing with stuff on the chessboard. Yeah. like I said, trusts have cognizance solely in equity. So if you're dealing with trusts a lot, you have to know equity. There's so much you can do, though. That is the difference. What's going on, Roots Run Deep? Yeah, absolutely. Absolutely. The Torah, the Tanakh, those are all equitable laws. Equity is the spirit or intent of the laws. When men make decrees and it doesn't, go in line with the spirit of equity, then they're not really laws. That's why you get all those color of law and things like that. But yeah, no, I mean, equity is the only way to really, truly operate privately. Anything short of that, you're just kind of playing around in their courts. It's the only way to invoke the Torah and the Tanakh. Equity is what allows you to actually invoke certain pleadings and certain, means of making things equal. That's why they say equity is a sort of equality. Because all those equitable processes, it's all about making things, equivalent. Yeah, that's really what's happening. Because everybody has colorable title due to the SSKV Acts. So, if you don't have both legal title and equitable use, meaning like legal possession, and the title to the property, as well as the beneficial enjoyment, then you don't have a complete title. So most of these people are going around thinking they have the entire title to everything, anything in the public domain, whether it's land, businesses, etc. If it's not in equity, and maintaining the title, even the legal title in equity to retain both sides of it, then, like I said, you only have half of it or part of it. You're doing 9/10 and 1/10, and you need all 10. Anything shy, like I said, is just different. Because even subrogation is different because, when one party has, been assigned the rights, to sue, or via equitable subrogation or legal subrogation where they've paid out the money, and then grants them the right to seek reimbursement from the party that's liable. Even in that same sense, it's all about making the scales equal. Everything in all of creation is a universal ledger. one giant bank. Well, that is an interesting point, because effectively them getting rid of a lot of the meets and bounds and not recognizing those in the at-law side, equity has to step in and complete that, because equity regards as done what ought to have been done. So trusts effectively are what's keeping everything according to its meets and bounds, via parcels and lots. That's how it is. But it's, like I said, it's how the estate is being held, how the trust corpus is being held. Is it being held in fee simple? Is it being held in fee simple absolute? Is it being held as, a life estate with remainder to another? Those are the questions that, really get brought in. Because when you really consider those different types of things, like I said, the entire mortgage industry is based on fraudulent conveyances. Because if people really understood what was going on, they wouldn't be doing it. But then they've already taken over the entire mortgage industry. Fannie Mae, Freddie Mac, and all that type of stuff. Everybody in the public is broke. There's no gold in circulation, so... And if you're in the public, you can't even have gold. Not technically. Because of the ongoing bankruptcies. It's a liability to them if you have gold in the public, because they're declaring that, everybody's bankrupt. So that's why they're going off a credit-based system. Even if there was a queen or king, you'd still be going off of estates. Estate law is actually under British law. American common law stems from British common law, especially with regards to estates and trusts. An estate is a form of trust. So when you consider, how the property is being moved, you have to, that's why, if you understand trust law to an extent, then it's time to move into understanding estate law in the sense, looking how the estates are held, with, if an estate is granted from, if A grants an estate to B for the use for the term of years, and upon death it reverts to the remainder man, which is C, that's, a life estate to B, with remainder to C. So, there's so many different things, when you start talking about fiat mints, fiat fees, and fiat fours, fiat fees to uses. So, there's plenty of stuff to be learned in that aspect, and it goes back that far, because you start talking in that language and understanding, it's the same things really. It works kind of the same way. It's just older language, and it's based on conveyancing. That's why you have to look into conveyancing, livery and season, livery and deed, symbolism, quantum entanglement, using a smaller symbol to convey the entire larger whole, things like that. But I mean, in essence, there's been unsurety in the realm for close to 600 years due to the titles. There's been wars and ongoing things like that. Most people are just, nobody has clear title unless it's been held in a trust. And the trust is a purchaser for value in good faith, bona fide purchaser for value. So, because then there's the equitable protection at law, a purchaser for good faith, purchaser for value in good faith. And then it retains the equitable interest. That's about the closest thing you can get to a clean title in the system right now. Because, like I said, everything belongs to the copper-colored Hebrews. And there's some possessions that are other Shemitic lineages, copper-colored peoples. But, yeah. But even a land patent you can't. That's not even sufficient enough, because even the federal government, they're only granting land patents to individuals. And what is an individual? 14th Amendment citizen, corporation. So when you consider that, it makes a lot of sense. The highest title you can have really right now is a trust, because nobody has fee simple absolute. That's why it's better to have that on your body than worry about the land you stand on. You have land that you're standing in right now. The corpus or the body. And it's been going on for a long, long time. Like, someone brought up to my attention the Doomsday Book in 1086, the year 1086. Well, that was preceded by the Ordinance of William I in 1072, between 1072 to 1076. And that's what separated the courts, spiritual and temporal. So they took a registry of all the property, and all the land that was condemned to that book. It was called the Doomsday Book. That was the Book of the Damned. And that tradition has continued. So when you see this, it's the same playbook. They declare something and then they go make a register of property. They declare another thing and they go make another register. It's the same thing. Same thing is happening. Nothing's changed. Not even the rules. That's what's going on, though. The estate is the body. The bodies of slaves. Or rather, the body of the representative of the slave. The slave is the account. But until you settle the books, they see it all together. And like I said, fee simple absolute over the body and mind and soul. That's the only way you can do that. Settlement, closure, and termination. Those three together. Settlement is the adjustments of the account, withdrawals and deposits to bring it to zero. Closure is that no new entries can be made on it to take it away from zero. And termination is the erasure of the account. The account no longer exists. That's how that's done. But if you simply just discharge the debt, by definition, discharge only means to put it out in the public and you're no longer liable for it. Though technically you kind of are. Like I said, if it's still in circulation in the public realm, it's still an issuance that you have to deal with. Yep, they did it by the rule of threes. Mind, body, and spirit. Or mind, body, and soul. That's why they did that. 3 SSKV trusts. But that's why they do that. Even certain things like the certificate of live birth, even that's not a complete title. But yeah, you have to get that settled. So let me see. You said 3: settlement, closure, and termination. Settlement, closure, and termination. Roots run deep. That's what it is. Termination is the the wiping of the existence of the account. The account ceases to exist. Let me see. But yeah, that's what you gotta get used to. You gotta get used to the old language. Once you get used to the old language, the new stuff is easy. And then you understand how things are moving. You just have to be able to correlate them to what it actually is according to old laws, and you'll see how the old laws are still in effect. And that's how you triangulate everything with 2 to 3 witnesses. That way you have a frame of reference and mindset, perspective of what's actually going on. Settlement and liquidation. Liquidation just means to take the funds from a frozen state, or in a let's just say a specific fund, that's not necessarily liquidated and converted into money of exchange. And that's liquidation is essentially when it's exchanged or converted back into money of exchange that's directly exchangeable, cash, credit, checks, bills of exchange, things like that. I mean, yeah, you're right. You do have to give them directives, but like I said, you have to know how to do it. Because if you don't know how to do it, they're gonna laugh at you. So, this is a book that Christian Walters heavily recommended. Absolutely. This is Law of Trusts, a treatise on the Law of Trusts by Thomas Lewin, Esquire. And is Frederick Albert Lewin. So this is something very, 1888. This is a very important book. Like I said, this goes into like the language and the conveyancing of language and stuff like that. When they talk about beneficiary, they say cestocade trust. Cestocade use is the same, generally the same. When they're talking about the trust itself and the relationship between the parties, they're talking about cestocade v trust. When they just say cestocade trust, they're talking about the beneficiary. Let me see if I can find provision. See, okay, here we go. Where's a good one? Yeah, it is. Let me see. Where's a good one? If an estate be settled on the first and then the other sons with provision. Oh, I gotta go back all the way. So, alright. Under this head, we shall inquire first who are meant by the younger children where the estate charged is settled on an eldest child. So the eldest being the firstborn or the oldest. Secondly, who are meant by the younger children, where the estate charged is not settled on the eldest child. Thirdly, at what time the portions vest. So, when a portion vests is when its possession has been taken and livery has been completed. Now, a lot of times when that conveyance is, effectuated, there are a lot of times obligations or impositions that are put in place, usually by a will, especially with dealing with estates, which you were leaving it in trust for another. Been many a precedent that have gone unchecked and unchallenged, and this is the position that we've come to today. So, who is it meant by, the oldest? So, generally, under estate law and heirship and testacy, the oldest child is usually the one that has the duties of dispersing the heir. Like, especially in the Torah and the Tanakh, past. Because ultimately, the estate was entrusted to, the father, and then the eldest child would have, usually man, would have the duty of essentially dispersing all the property, that was, left or apportioned to the other heirs, which would be, the other children or things like that. So in that sense, that would be their duty. So they would be, it creates a trust obligation, because the estate in its entirety, is not just being conveyed to the eldest child. There's an equitable duty, a fiduciary duty, trustee obligation, to hold in trust the portions of that estate that pass to the other siblings. So, that those obligations, still have to be fulfilled, and it constitutes a breach, especially when the settlor or the testator, in this case, the testator being the one that left a will, bequeaths via that will to the second oldest or the third oldest, however, having the entire thing vested or settled upon the eldest child. And when that happens, like I said, he's trustee in the aspect of, he's trustee of the estate for the portions that he is not going to be benefiting directly. And that's how there's a fiduciary obligation, because like I said, he does not get the use or the benefit, the enjoyment of all of that property. There are specific provisions in that said will that force him to, take on a fiduciary responsibility to his siblings. So this is something that was very, heavily considered, and why in certain cases, especially when the eldest was either incompetent or very irresponsible, that, that somebody could be disinherited from a will, especially during those times, and even today, to be honest. So, it says, so first, who are meant by younger children, where the estate charged is settled on an eldest child. And it says, 1, the court in the case of portions, observed Sir G. Turner, seems to have regarded rather the purpose than the words of the instrument. So this is inferring intent rather than the letter of the law. And in this case, the law of the trust would be the trust instrument. So he's inferring the equity looks to the intent rather than to the form. So, it says, and also, in some of the cases, indeed, the court seems almost to have carried into effect the purpose of the instrument in opposition to the words. And although in the late cases more weight has been given to the terms of the instrument, there can be no doubt that in cases of this nature, very great attention must be given to the purpose of the instrument. So this is basically stating that, regardless of the settler's or the testator's use of language and whether or not it was actually effective, the court has the duty, like I said, the equitable charge, to look to the purpose of the instrument, what the testator was, intending to do via the conveyance and the grant of power or property. And then it says a general rule. In the first place, then, let us see in what cases an eldest child actually will be regarded as a younger child constructively, or, which is the same thing, in that cases a younger child will be deemed the eldest child. Every child, said Lord Hardwicke, except the heir, except the one, i.e. except the one who takes the estate, is considered in equity as a younger. An eldership, not carrying the estate along with it, is considered not such an eldership as shall exclude, viz., from sharing in the portions provided for younger children. It would be hard that the right of eldership should be taken away, and yet not have the benefit of a younger child. So, basically, this is kind of pointing out to there's a fiduciary obligation from each of the, succession of, age of the different siblings, having the duty to give to the youngest child who is of the least in terms of seniority. If therefore, before the period fixed for distribution of the portions, the estate shifts either by the original limitations or by appointment under a power contained in the settlement from the eldest child to a younger child, this would be considered like an assignment of interest in a sense, but it's really a power of appointment, and under today's laws you would be looking at like the Power of Appointment Act of 1951, is something Gene Keating talked about. Settled in the settlement from the eldest child to a younger child, the younger child so taking the estate is treated as the eldest, and the eldest child losing the estate is deemed a younger child. Thus, in the leading case of Chadwick versus Dolman, a father on his marriage settled an estate to the use of himself for life, so he made himself a tenant for the life estate, with remainder, so he's appointing a residuary beneficiary subject to a jointure. A jointure is a marital trust established through the status of marriage or beforehand, to the use of trustees, so the benefit going to the trustees upon trust within 6 months after his decrease to raise 4,000, I'm not sure if that's pounds or what, for younger children's portions as the father shall appoint, or in default of appointment to be divided amongst the younger children, with remainder to the use of the first and other sons in tail. So a lot was said there. So to break that down, so settled an estate to the use of himself, so he settled upon himself, so he's the settler of the estate, or in other words the grantor. Now what is he doing? He's granting the interest in the estate. He's holding the trust inter vivos for himself for life, and upon death, which is why it says with remainder. So with remainder, so there's a portion that goes to the wife for the jointure because of those provisions under that trust, and to the use of trustees, that means there's a conveyance to the trustees because the use is the use of the property. The trust, he has the right to use some of the property, especially in the trust instruments, but it is subject to the benefit of the enjoyment being held in the beneficiary. Upon trust within 6 months after his decease, raised 4,000, whatever that is, for the younger children's portion as the father should appoint, or in default of such appointment be divided amongst the younger children. And then it says with the remainder to the use of the first and other sons in tail. So, and then it's stating that the use goes to the trustees who are supposed to raise capital, it says right there, and then after they have fulfilled that purpose for the trust, then the estate vests in the eldest, and for the benefit of the other sons in tail. Now, what is a fee tail estate? A fee tail estate is usually when someone has the right of remainder, or they're considered a remainder man in trust. So that's when they have the beneficial interest in an estate specifically, and they have the right to claim it after everyone else has used the property, whether or not there's been a detriment or there's been fiduciary breach or etc. They're at the risk of all of that, and that's where they're at the end. That's why it's called fee tail. So when they talk about the capital or the principal, the head, capitis means head in Latin, and fetail, for the remainder. That's what that means in the scripture by the head and the tail. This is something that goes back much farther, but this is how estates and conveyancing works. So, just with that, any questions so far on that? I know it's quite a lot as far as language, but provided that you understand trust law, it's not terribly hard to navigate. It's just a few different terms that are different, and it's slightly different as far as how it works. It's the same concept. Because, like I said, that's why I keep talking about, remaindermen and uses and life estates, being a tenant of the life estate, things like that. So those are something to be aware of. All right, continuing. So, let me see. So let me see here. Where did it start? Okay, so there were several children of the marriage, viz. Humphrey the eldest. So Humphrey was the eldest child, and Thomas, John, Lewis, Anne, and Dorothy. So there were 1, 2, 3, 4, 5 others that were younger. So it says, by a deed dated in 1686, the father appointed the 4,000, I don't know if that's pounds or shillings or what, giving 2,600, part thereof to Thomas the second son, on the occasion of his marriage. So it vests upon him fulfilling the conditions. This is common when you see certain classes of beneficiaries or terms of use. Terms of use directly derives from a class of beneficiaries that has to meet a particular condition or purpose or some type of usually some type of condition in the terms that upon meeting those specific conditions, then that property vests. So this is still valid to this day, something like that. And after this, Humphrey, the eldest son, died in his father's lifetime without issue. So without issue means without kin, without seed. And thereupon the father appointed the 2,600 amongst his younger children other than Thomas. So there were 5 others, other than the eldest. The eldest was, Humphrey. So the second oldest was Thomas, and he passed without, children. So the remainder, when you see John, Lewis, Anne, and Dorothy, the remainder, the 4, were next in line on, heirship. So amongst his younger children other than Thomas, on the death of the father, the estate devolved on the second son, Thomas. And then the question arose whether the first or the second appointment was good, or in the other words, whether Thomas was entitled to the 2,600 as well as the estate. The Lord Keeper said he admitted that Thomas at the time of the appointment was a person capable of taking, and was a younger child within the power, but that this was a defeasible appointment, meaning it could be defeated, not from any power of revoking, or upon the words of the appointment, but from the capacity of the person, because he was deceased. He was capable of taking it at the time of the appointment made, but that was sub modo, and upon a tacit or implied condition that he should not afterwards happen to become the eldest son and heir, so that he had, as it were, only a defeasible capacity, and it was therefore adjudged that Thomas, who took the estate, was not also entitled to the 2,600. So I guess it would devolve back to the eldest in that sense. In this case, the second son would be succeeding the estate, and so becoming the eldest was deprived of any share in the portion of the younger children, and no claim appears to have been put forward on behalf of Humphrey, the eldest son, to stand in the place of a younger son. But it has since been settled that under such circumstances, the eldest son, even though he died in his father's lifetime and sustained up to his own decease the character of the eldest son, but never eventually came into possession of the estate, is entitled to be treated as a younger son and to share with the other portionists. Thus, in Davies versus Huguenin, the estate was settled on J. Davies and his wife successively for life, remainder, so you have a tenant of a life estate there, and with the remainder, the right of remainder, to the children as he should appoint, and subject as aforesaid to the use of a trustee for 500 years for raising portions for younger children, remainder to the first and other sons in tail. So, J. Davies had 2 sons, William the elder, John Stanley the younger. William attained 21 and died in his father's lifetime. It was held that his personal representative thereupon became entitled to a portion, but a subject to the exercise of power of appointment, because that is a taxable appointment. So, these are something to be aware of, These are like the languaging in the white trust. When you consider, what the white trust is, you're dealing with, like I said, estates, dealing with the remainder, the uses, for terms of years, conditions, etc. That's when you get into the older trust language, when it goes back hundreds and hundreds of years, and then beyond that, it goes into other languages, which at that point you're almost dealing with Hebrew. So that is something there that allows you to really understand. That's at a pretty sophisticated level. Like, not gonna lie, it's at a pretty high college level. But when you get to that point, like I said, other trust law and the way things are set up now it's very, very simple. So any particular questions on that? I know that was the languaging is different. It's very different from what people are used to today. And that's something that, like I said, it does get easier the longer you study. It does take a little bit of time to wrap your head around, to be honest. And it took me a decent amount of time. The way that I really actually understood a lot of that was looking up what those words mean: fiat fee, use, fiat for, fiat meant, things like that. Remainder man, etc. Those are the terms that I would be looking up to get a better understanding of, how trust law actually works, especially in dealing with conveyancing and livery of estates. That's why it matters how the estate is being held, because an estate can be held as an equitable estate or it can be held as a legal estate. Usually legal estates are estates that are not complete in, conveyancing. So that is something that I would be aware of when you're dealing with that type of thing. Usually it's because there's some type of tax that's owed. Because, like I said, they don't want to recognize trusts in this realm. So, if it's held in a legal estate, then there's, so many more taxations and conditions that can be alleged for taxation. So with equity, it goes straight to the beneficiaries, and that's how it vests in that sense. Any thoughts on that? Like I said, any questions, any thoughts, put it in the chat. Absolutely. Absolutely, John. But, another good resource to read, especially with dealing with specific topics, is William Blackstone's Commentaries on the Laws of England. This tells you not just about trust and conveyancing and other things. It tells you about, a myriad of different other relationships and aspects of, old English society, that I would I would recommend reading into. Carissa, it just depends on what trust you're talking about, what estate you're talking about, because the trusts are considered equitable estates. In the legal estate, you want to be grantor, beneficiary, and also the executor. In the public realm. In private, for your own trust that you just you establish and all that, generally you want to be grantor, trustee, because you have the control and possession and determine the means and mode of running it. But like I said, you need to know that Robert's Rules of Order, how motions are carried, how to run, because those are mainly for board meetings, like boards of trustees, boards of directors, things like that. So the difference is grantor, beneficiary in the public on the legal estate, grantor, trustee in the private for the equitable estate. Is wife's different from other trust approaches? Yeah, I mean, it does differ. There's plenty of different types of trusts that you can use. Like I said, he uses an older form of using a debt or something pledged as, almost in terms of escrow to fund the trust. That's what's actually happening, because when you read the trust documents in the Weiss Concise, there's an assignment of wages or interest, future interest and wages that's happening, and that creates a debt, but that debt is an asset to the trust itself. So when that debt that's acquired as an asset is met with the actual funds or the salary at that time, it's treated as a debt being fulfilled, and it's not the same as capital gains or it's something like that. Like I said, it's not legal advice, financial advice, or tax advice, but that's what it is. So, it is an irrevocable express trust. So express meaning written, irrevocable meaning that the trustees cannot change the terms of the trust instrument. Now, things like successor trustees and trustees on the board, even beneficiaries, can be changed according to the board of trustees per the powers delegated in the original trust instruments by the grantors. But, the trust itself cannot be changed, meaning the language of the instruments, which is what makes it irrevocable. And the fact that the settlor loses, control of the actual property when it is sold and conveyed to the trust. That is what makes it irrevocable. So, if it would be considered revocable or inter vivos if the grantor retained the use or the control of the property during his life. So that is the ecclesiastical trust. How does this differ from 508c1a? 508c1a is considered like a statutory trust. A lot of times it's obtaining a status that's recognized under statutory law. Usually like a ministry trust. It's not a bad thing. Like I said, it's just something you have to, there's a lot more due diligence required, because you're not only, because in a sense, I'm familiar with trust laws dealing in foreign jurisdictions. when you deal inside the jurisdiction and you're claiming status within the jurisdiction, you have to know a lot more how to operate publicly, and the remedies and defenses and different things you can go about to affect certain things. And absolutely, John, it is an older idea, but it's still valid. It is, yeah. Hey, Goldsmith, if that's how you got to do it, shoot. For me, like I said, I've been studying like heavy trust law. Like, I've been hearing about Lewin for years now. Like, the only way I actually understood it was when I looked up what the words meant and how the estates were held, and I kind of correlated it to the different aspects of estate law. That was the only way I was able to get it. Aside from that, yeah. Absolutely, Carissa. But, I mean, like I said, when you get used to this language, normal trust law, even, express trust is easy at that point, because there's way less going on. That's really the only difference, is that under state laws, especially the old conveyancing, where you have remainder and certain things, and people were more privy to the understanding and granting of things in a will, there's just more going on. That's really all it is. When you understand that, it becomes a lot different. But yeah, but that's a look into the older laws. Like, when you start going past, I want to say about the 14 or 1500s, I think the language changes again. Like I said, English stems from Hebrew. It didn't stem from Latin. And that's what the people came in the 1500s. They came here speaking Latin. That's not what originally was there. So, it couldn't have derived from Latin, because the people here were already speaking English. So, yeah, it's like I said, it goes into old English when you start talking about the Doomsday Book and things like that. That's old English. But yeah, things prior to that, I want to say about 1500, mid 1400s to 1500s, and onward, is still the same, technically the same language. Yes, that's what they do. They do everything in Latin because it's, like I said, that's the language that they spoke. That's who essentially conquered. One of the peoples. There's still a bunch of them, Psalms 83. But that was one of the peoples, especially with the Dum Diversus and Unum Sanctum and all that. The Roman Catholic Church. But that's also because they're spells. It's the language of the dead. But yeah, that's how that's going there. Anybody have any questions, like, as far as the old languaging and like something they're unsure about, or what it means, how it's applied, anything like that? It's all good, Chris. We all have more to read. A lot of these things I still got to go back and read more of myself. I'm not exempt from that. But yeah, they give you a window into what people were dealing with at their core issues in the past. So, records are the vestiges of antiquity and truth. That's actually a maxim. They give you an insight of what people were dealing with, how they moved property, what their lives were like, what they were considering upon their deaths, things like that. Key matters of society. Actions and conduct were, I'd like to say they were different, but you still had inheritance theft and things like that. So there's always plenty to consider in that respect. Plenty to consider. Yeah, like I said, it doesn't actually take any language to create a trust, but there has to be, an intent, a purpose, and an understanding between the grantor and the trustees. That there was a trust. I mean, there'll still be a trust and, trust there, but like I said, the intent and purpose have to be manifest. So, whether it's expressed or not, it's something there. But, your actions and conduct absolutely create trust. They absolutely create trust. That's something you always be mindful of, especially when you're dealing with deposit accounts and things like that. Everything we do is trust. Promissory note is a trust. Application is a trust. It's an application to the trustee of the use of certain funds or monies of account to apply to certain debts. That's what an application is. The application of lawful money to a particular purpose. That's what an application means. So, like I said, everything we do is trust. Especially where there's no valuable consideration for, two parties to equally contract. But that's what allows you to be able to do a lot in equity. Trust and conveyancing and livery. And ChatGPT is good, but like I said, you have to have a base understanding on the subject, otherwise it'll send you off the rails. You have to know what you're looking for if you're dealing with ChatGPT. Because it'll do a whole bunch of things, but it'll test you too. So, but yeah. There's a lot of freedom in trust. Because, trust law is the highest form of law. It's what a state law is. Well, like I said, it's not just through, let's say, per se, a statement. It has, there's a lot that, could be inferred through certain other trust instruments and things like that. And mind you, you do have to be aware, though, that under the legal estate, you're not actually the settler. The way that you become, in essence, the same status as the settler is because the status of the mother in captivity is, the status of the children follows that of the mother in captivity. So that's why, the mother being the settler, granting the child to the state, and name to the state, and the child being a beneficiary thereof, that's what you're dealing with. So, that's something to be aware of. But, you retain that right of action or that cause of action to be able to change the intent or the purpose of the trust, because the mother loses that at 18. So home ownership trust just lacks the trust terms. No, generally it has the trust. I mean, like I said, when you have the deed of trust, you have the promissory note, they put escrow on the trust and all that. The only problem is they gave you the trust outright. Then you repledged it as collateral for the debt. And then they created a trust out of the promissory note where they were the grantor and you weren't. So they misconstrued the trust. It still is a trust. And it has the trust terms. They're just not favorable to you. But since you were the one that conveyed it to them and pledged it as collateral, you're the grantor. So you have to correct that misunderstanding and that mistake in the court. And through your actions and conduct. Expressing the trust, after the fact. That is something that you can do, especially when there was a mistake or there was a valid intent to create a trust, especially after a conveyance. Yeah, I mean, that's really what happened. It's called a bait and switch. Biggest example of that is like the Indiana Jones when I think it was the Crystal Skull, when he took that thing and put the weight in its place. Didn't quite work the way he wanted it, but that's another example of that. But that's what allows you to be able to come in and reconstrue the trust, because construe comes from construct or constructive. I know it doesn't seem like that, but that's the word it's related to. So they changed it most likely to prevent people from understanding what constructive trust is. That's why it says construe, because it's from construct. And yes, courts are the ones generally that set up constructive trusts. They're the ones that give declaratory relief and establish those trusts under court supervision to be able to enforce the settler's intent and purpose. Now, the problem becomes a lot of times when it's not going in your favor is who's the grantor, because you have identity theft. They stole your identity as the grantor. So you got to deal with that first, showing and proving through actions and conduct and proof and records you are the grantor. So that's where it comes in. You have to do your due diligence and bring in the prima facie evidence, mailings and writings and indenture agreements to prove you are the grantor. You pledged the collateral. When you pledged that collateral, that was the grant. It wasn't a suretyship per se. It was the grant, not a guarantor, a grantor. But like I said, until you express that, and they're misconstruing the entire trust because of identity theft, you're going to have to deal with the taxes until you deal with that, because the trustee is liable on the taxes for a trust. So, you got to correct that. But that's what allows you to be able to come in and correct everything. Like I said, everything in court is a tax issue, because it wouldn't be in court if there was no tax to be paid on it. It would just directly pass. But you're dealing with old laws. Pharaoh taxing the dead or entities, things like that. Now that's what you're dealing with. So until things are changed, but well, it is. They want to drag you into court because the court is beneficial for them, because they have all the resources and time to spend. 3,000 hours a case a lot of times to be able to just with multiple attorneys and all this stuff to look at all these statutory remedies and things like that. I mean, that's why they want you as the surety instead of the grantor. The grantor is the one that determines the law of the trust. So they don't want you as grantor. That's why they stole your identity. That's not necessarily the case. I mean, there are actually some various things in that law that can be used, very seldomly, I will say, though. But I mean, honestly, the main point is really just to get into chambers, get in camera, have a protective order, seal the case, get a seal on all the filings and certain things due to confidential commercial information or, trade secret information, things like that. That's really what you want to deal with. I mean, anything short of that, you're going to be, yeah. So, I mean, they are presuming we are trustee in court. Would proof of the executor status correct that? No, you have to literally re-express the mortgage or the trust to, via evidence and writings and certain things, like even necessarily on the, the return receipts and green cards and things like that, by grantor, by beneficiary, things like expressing, even through multiple records and means, usually on the basis of 2 to 3 witnesses, reconstruing the trust. This is what it means, prima facie evidence, at first face. The rules of signatures, the rules of forms, regaining that prima facie evidence. Because it becomes mail fraud if they don't send those things back. So, you got to deal with that aspect of it. Like I said, executor is just on the legal estate. That's on the whole thing. When you're dealing on the mortgage, that's a sub-trust. So you got to deal with that particular trust. But that's what happens. Because, like I said, they bring you into court, and for something like that, you're dealing with, the trust. They're presuming you to be the trustee. You are the guarantor that, because they're still acting like they own the property when they granted it to you, because everything is prepaid. I don't know about that, John. The plaintiff is usually the alleged beneficiary, which is why they're even bringing you into court. The defendant is presumed to be the trustee in breach of trust, which is why there's because there's a tax owed that you didn't pay from the onset due to the mortgage. So that's what you're dealing with. So, and then when you reconstrue the trust, then they're liable for the tax, which is why they even misconstrued the trust in the first place. They were avoiding capital gains tax. So, due to their status as corporations and things like that, they're not doing business right. So, if they were doing, they're in no position to be able to do certain things. It would give everything away, and then they just can't do it. So, I mean, like I said, the tax is the main issue. If you don't handle the tax is, that's it. That's the main issue. That's why people are in court. There's a capital gains tax. That is the reason why the court action even started in the first place. So they're foreclosing on the trustee by the beneficiary. The beneficiary is the one that is foreclosing. So the fact that they're even foreclosing means that they're presumed to be the beneficiary. So you gotta, power of attorney. Generally, power of attorney is how they grab it. Whether it's implied, through adhesion contracts or clauses in a contract to do that, or, otherwise. I mean, that's generally where that type of thing happens anyway. What's going on, Niles? But I mean, the notary doesn't necessarily have the power. It's the grantor. The problem is they stole people's identities. So until you construe the trust again, or pay the tax. Which, when you pay the tax, then it really proves that you're the grantor. That's why they didn't pay the tax, because they couldn't. You were the grantor. Absolutely, Christian. Like I said, that's, the what tax, I can't talk about that, but most people are, it's a capital gains tax. And that's like the main issue. Like I said, Gene Keating talked about all that. Every case is a tax issue. Who is paying the taxes? The trustees got to pay the taxes. So, that's why they want to know who is the trustee, who has the right to make a claim, who is the beneficiary, the beneficiary making the claim. Things like that. Who has standing to foreclose? Who are the parties? These are all the different things that are discussed and considered in court. They do, but you have to have qualifiers before the use of notary that it says is not for entrance into a foreign jurisdiction, or, things like that. And that it does not constitute, adhesion. But you got to kind of make sure all those different clauses are there. But when you properly do it, it doesn't get treated the same way. So, that's just something to be aware of. Like I said, the notary has a lot of power, but trust law has more power. So, like I said, you have to reconstrue the trust. And one of the best ways is to pay the tax. The grantor pays the tax. So, or the trustees. One of the two. The fact that they're construing you to be the trustee and they can't pay the tax means that you're the grantor, generally speaking. Not specifically, for anyone's situation, but yeah. So those are all different things that you got to bring in, and like a lot of, when you reconstrue the trust, a lot of that is confidential, because confidential means trust. So you got to bring that into chambers, bring it in under seal, get a protective order on it, etc. So you don't want to breach your own trust. You want to handle it accordingly. You bring it in the right way. So that way, you're not producing evidence of incompetence right there in the court for the court to take a look at and say, I think you need a psych eval. And that's when you breach your own trust. Or you put too much in the public side of the court. There are public matters and there are private matters. Not right now. I'm thinking. Send it to my email. To be, number 2, BE, Fruitful, and then the letters TG for training group. So tg@gmail.com. And that's where you can send it. I can't really use links on here. But thank you now. But yeah, realistically, like, people need to start getting used to, operating, public and private. There's two side ledgers to the court. The public side is the debt side. The private side is the asset side. So you have to move both sides of the court accordingly. When you do, you'd be surprised how far you can get. So, that's what you got to be, aware of. But like I said, once you understand it and you understand conveyancing and how powers vest, how property vests, how it is settled, the uses of property, all those, how a property, the right of remainder, things like that. Like I said, I would look into those different things. Once you understand those individual concepts, you kind of see how they're arranged in, like, things like, the Treatise on the Law of Trust by Lewin, and you kind of get a better sense of what's going on. Because at first it just looks like a whole bunch of moving pieces, and it's not really making sense. Like I said, break down what the words mean. Once you understand what the words mean, then understand what's going on, the right of remainder, the uses, the remainder man, fee tail, fee simple, things like that. So, that's how I would suggest going about it. And like I said, when you understand that type of law, like I said, other trust law is way easier. That's why the grantor is commonly referred to the settlor, because settlor is for an estate, grantor is for a trust, generally speaking. But it does allow you so much more latitude to be able to move and decide how you're going to run your business, your corporate, your company, how you structure your business, how you structure your trusts, how you want to operate. It gives you the flexibility of choosing what, tax jurisdiction you're in, what tax laws you play by, how you convey your trust to benefit you the most lawfully and legally, in taxation and things like that. So there's so much that you can do, that like I said, it really does benefit you a lot. Like I said, you just have to know what you're doing, and that's where that knowledge level has to be. But once you've met that, like I said, you just see what's going on, and things are so much simpler. Especially dealing with your own property, when you have assets and other things like that. When you're able to manage your own affairs, and you don't need a curator, tutor, or guardian. The courts as a guardian, and you're able to manage it effectively and lawfully. You're a king in your own house. And that's what's written in scripture and other maxims of law. So, like I said, there's a lot of potential that people are able to look into, but you just have to have that knowledge level, there to know what you can and can't do and trust. So that's what, like I said, that's what frees you. Self-governance frees you from somebody else having to run your affairs. Somebody's got to run it. It's either you or someone else. If you don't know how to do it, someone else will have to. Anita, it's not the easiest. Christian Walters referred to it as the white trust. You have the white trust as the private trust, and then you have the black or statutory trust as the legal entities per se. So it's not necessarily easy at first. It does get easier, but like I said, you do have to study. It's like it's like going into high school, not barely in algebra, and then having to look at calculus. Like, it's different. It's very different. It's another different language, but like I said, all these different things are all languages. So legalese, equitable terms, banking, like each one of these aspects has its own language. So if you understand the language, you'll be able to better understand what's going on. And once you understand what's going on, you see how to move around, see what you can and can't do, and what will create a taxable event, what will not create a taxable event, how to properly pay the taxes, things like to actually settle, close, and terminate the obligation, instead of just circulating it out somewhere in the public for the Treasury to have to handle at some point. So things like that. But yeah, like I said, it's not easy at first, but eventually, like I said, Gilbert's law Summaries on the Law on Trusts, and then Corpus Juris Secundum on Trust, Book 90. Those help a lot as far as gaining that understanding, and then you're able to correlate it and cross-reference it with Lewin and things like that, and it makes a lot more sense, especially in trusts. Suits and Chancery by Gibson, things, But like I said, it gives you have to kind of put it together, what was going on, how was society in general. Generally these other societies were far more advanced than we think they were today, or we've been told. Untold technologies were had in older civilizations were honestly one of the most primitive as it currently stands. So, getting rid of that assumption that we're the most advanced technologically is kind of what opens up the mind to being able to see how things were, and that creates a lot of room to grow. So I hope that was helpful. Because there was a time when all of this stuff looked like gibberish, and I was just sitting there like, huh? And like I said, you have to kind of, hack at it bit by bit until you understand what's going on. But the reason why, those particular languaging haven't been used in a while is because court precedent changed, and the means and mode of conveying property without it being taxed into oblivion changed. So, to actually preserve certain things. I know. Yeah. We are the most dependent on technology, and we're not actually creating as much technology, so it's very different. Yeah, you're right, now. They did tear it all down. They didn't control it, so they had to tear it down. And the people that instituted the society today are somewhat the least technologically advanced, except for weapons of war. And that's what they've retained and picked up from prior civilizations and empires. But yeah, they really did tear everything down. Literally and physically. Or excuse me, literally and figuratively. Yeah, you're right, now. Like I said, only the Most High that created wisdom and understanding and knowledge, only the Most High can grant these things. So, just ask the Most High. The Most High is the grantor that settled the duties upon Adam for the dominion of the earth. So only the Most High has the power to grant understanding and wisdom. But when you get to that point, like I said, just bit by bit, if you're not sure what these words, sometimes you got to take it one word at a time, literally, to break it down. If you don't understand this word, okay, you move on. You don't understand that word, you look that one up, okay, you understand that one, you move on. And you take it and just bit by bit. Yeah, you're right. That's where wisdom and prudence and understanding and knowledge come in. Because you need these things, especially when you're dealing with judicial actions and judicial matters, things that require governance. You have to understand these things. So it takes all of those things to be able to do it, righteously and upright, in an upright manner. I mean, my thing is like, it's an unconscionable contract, so I'm not trying to retain something like that. There are credentials that they can give you in the private that supersede stuff like that. But I don't know. For me personally, Like, I wouldn't even go with the driver's license. Why would you license the state to allow them to use your body? That's the vehicle that you're being licensed to drive, because they're stating that you don't own your body. So, I don't know. As far as endorsements on any identification, like all rights reserved, without prejudice, things like that. Don't use the UCC codes. It's jurisdictional. Don't use other things, but like I said, state IDs is probably, you can travel with state IDs. That's why, identification of the proper party or the beneficiary. But, grantor, beneficiary, all rights reserved, without prejudice, things like that. Authorized representative, bare minimum. I wouldn't give them no type of blank endorsement, but I wouldn't recommend getting a driver's license either. It's a bad contract. Well, UCC is copyrighted, so don't write UCC. Read the code. It says without prejudice. It means with complete reservation of all your rights. Well, that's an option, Carissa. State ID is better than a driver's license. You still got to reserve all your rights and sign certain things like without prejudice and all rights reserved and things like that. But it's better than nothing. Especially if you can't get the driver's or the passport and certain things yet. State ID is better than a driver's license. You can travel with a state ID, but you have to know how to articulate yourself, and you have to have some papers, fee schedules, etc. State paperwork, trust, things like that. So that the trust is the owner, that you're just operating and you're just traveling. You're not operating the vehicle, you're traveling. And I wouldn't mention business, commercial activities, or anything else that's a portal term to that. It is. You are the goods. That's how it works. But it's better to be identified as the grantor and beneficiary per the rule of forms, rule of signatures, rather than seeing as the licensee. That's why the roles, understanding your roles and powers and relationships is so vitally important. Driving is a commercial term. Operating is a commercial term. Vehicle is a commercial term, although there's other things to replace that, conveyance, things like that. But like I said, if you go into a conveyance, there's taxes involved there too. So you got to be careful what you say. Generally, you're just traveling. So you say that. If you're not making money, you're not hauling goods or certain other things, you're traveling. Then, by air, land, or sea. Don't make it an insurance issue. Yeah, that's exactly what this is, Carissa. The upside down world. Stranger Things. That realm was the void. The upside down world. Yeah. Although, like I said, it's kind of hard to call it that until you get the MCO or the MSO. Because the state presumes to own it. If not. But you got to be careful too when you're talking about conveying goods. Like I said, conveyances, there's taxes on it. So, like I said, the best best route is just to say you're traveling. I wouldn't even bring up conveyances or anything like that. Automobiles or instead of motor carriages. And you're just traveling. Unless you are moving goods and stuff for hire, then you are considered driving, but yeah. Nope, operator is a commercial term as well. I wouldn't say you're operating either. If you're operating, you're in the opera. And if you've seen the movie Tenet was a wild movie, but that's probably one I haven't really talked about too much. But if you watch that movie, it shows what's going on. They have that potential to be able to reverse entropy in certain things. May be the case why they say certain fruits have been irradiated, because I've worked in other industries where, you know, fruits and other things are, you know, shipped and transported, and I've never known anything about irradiating anything. And you know, you watch Tenet and you'll see what I'm talking about. Rotas, Seder Square, things like that. Opera. The Traveler. Right. Until you can prove otherwise that you own the automobile outright, they're going to consider it their investment. And it is an insurance issue because until you own it entirely, they own it. So traveling, things like that, yeah. It is. It's chess, not checkers. But even in that, there's multiple layers to it. So you gotta be very aware of how the pieces move and what they're capable of. Occupant is generally considered enemy occupants. So that's not really a great term either. It goes into the laws of war when you deal with that. Like I said, traveler is the word. Travelers travel. And travelers are what, you know, in the process of traveling. I mean, you can. It's not a bad idea. Although they're not going to want to go back and forth with you on that. But a lot of times they're going to just say, leave that for the judge. Yeah, absolutely, Roots. Traveler. But you got to have your records to back up what you say. Like I said, if you have a driver's license and you have no state ID, then they're going to be seeing, you know, they're going to look at you like, are you driving? You can get a state ID though. But like I said, the passport is what the best means, but you got to have the authenticated certificate of live birth and things like that before you do that. So, yeah. Nope. That's how they know. State ID is for traveling, driver's license is for driving. If you're not operating in commerce, there's really no reason to have a driver's license. Not unless you do drive. But they just presume that because you have it, you're always doing it. Until you show otherwise. They don't know when you're making money and when you're not. They don't really care, to be honest. I mean, That's when it goes into a gray area. That's, you kind of have to know case precedent and things like that, how the Supreme Court has upheld the right to travel, not necessarily the right to drive. Driving is a privilege, commercial term. Traveling is a right, upheld by case precedent, Supreme Court, etc. So, I don't know. It's kind of a moot point arguing them with them a highway, roadway, common way, things like that. They're going to say because they pay because they're the trustee on these things and they pay for the improvement of certain things, they're not going to listen to you on a lot of things. Like I said, it's best to just do as little as possible. You're not really trying to start an argument or a controversy. You just look to go about your business. That's really all it is. You're not looking for a fight. You're not looking to start one. You just mind your own business. That's what that means. Yeah, you always want to avoid confusion. Confusion is how they get people hemmed up in a lot of things. People agree to say things that they don't mean because they don't understand. That's one of the biggest problems. If you don't understand, don't agree with it blindly. There's too many people that go along with too much because they just don't understand. And you always have to understand what's going on. You have to think about what is the present situation, what is being presumed here, what is actually going on here, how do I operate knowing these things. You know, if something does not go in my favor, how can I remedy the situation while here and now, and what can be done later. That's just people. I'm just outside. I'm not worried about that. They just got loud exhausts. But that's really what you want to be looking out for, you know. Like I said, know and understand the rules. Look up authorized representative in the UCC. Why you even sign like that. You don't actually use the UCC code itself. Read what it says and then see how. Well, yeah, it's a marriage between you and the state. That's what it does. It's the status of a jointure or a coverture. Married to the state. Under parens patriae, the power of the father as the state. The court is the guardian of all the wards, the orphans, the insane, and what was the other one? And the fatherless? No, orphans, insane, something else. There's another one. Oh, for what is it? Is it women? I think it is, yeah. For women, no, for children. That's what it is. For women and children, orphans, and the insane. When you're dealing with family court, you're dealing with a lot of presumptions. You have to manage the presumptions a lot of times without necessarily directly attacking them. You have to rebut them silently a lot of times. Sometimes openly. Just depends on the situation. You know, a lot of times the defendant, the bonds are put in the defendant's name. So, requesting the bid, performance, and payment bonds and appearance bonds, things like that. Doing audits and other things like that properly, for your interest in the case. Especially when they're creating a taxable event and they're not reporting the tax correctly, 1099 OIDs and things like that. There's other forms that go along with it, but yeah, like I said, when you're dealing with discharge or payments, or tendering of payments, things, anything like that, merchant loan, settlement of accounts. A lot of times you're dealing with UCC, but quoting the actual UCC code doesn't work a lot of times. Because why? Because the UCC was codified in every state as something different. For example, Texas UCC is called the Texas Business and Commerce Code. In other states it's called other things. Georgia, I want to say it's like Title either 11, I think. Title 11, I think it's in Georgia. So it's called something different in every state. By actions and conduct is how you quietly rebut something. You don't necessarily have to expressly state it, but by, a certain condition, like, for example, having certain properties in trust, or, conveying them in trust, validly, that changes the entire status. And, depending, you can, even if you have an action going on, things can be done. Like I said, they just have to be handled a specific way. The deed, authenticated certificates of live birth, it's wherever the deed is found. It's considered, bearer form. But when you're not dealing with unauthenticated, you got to deal with where the property is. Where's the property? Okay, you deal with it in that county. So, but yeah, generally through your actions and conduct, and generally the situation of the status of the res. It's generally how you do that. Dealing with subject matter jurisdiction and things like that when you're dealing with that type of scenario. That's generally how you quietly rebut it. You're not directly addressing that issue, but you are using something else, and that it implies certain things. Usually you're being expressed about another matter that supersedes what you're talking about, generally speaking. But it's not for everything. And it, there's certain things that do still have to be expressed. It's just not everything. The implications of certain things and other matters, you don't generally always say the implications, because judges can read that. They understand that. They're not stupid. You might not be always doing things in your favor, but they're not stupid. So, but yeah, that's really what you're dealing with. Like I said, family courts are actually, they might not be necessarily courts of equity themselves, but they're generally invested with powers of equity. So you want to stay with clean hands the entire time. But especially when you have, certain presumptions or certain things where you didn't have notice, you're entitled to take certain actions, like without having to worry about certain things, But yeah. Like I said, there's always a remedy. You might have to do a little bit more. You might have to go certain places to take care of certain things, depending on the situation, but it can be done. Where there is a right, there is a remedy. Ubi jus, ubi remedium. So, the biggest thing is just not getting so lost and all of that and losing sight of what you can do. A lot of times, presumptions are changed to the point where a lot of times you got to make sure everything is lined up. You can't list property that you don't have the deed to, or you're not like recording the deed with. So you have to record the deed with the property. That's one thing. And then there are codes, to prevent them from denying you. Where is it? Oh, here it is. Okay. So, under Crimes Against Justice, this is title, what is that, 70, title 70. Every person who willfully destroys or attempts to destroy, or with the intent to steal or destroy, takes and carries away any record, paper, or proceeding of a court of justice, filed or deposited with any clerk or officer of such court, or any paper or document or record filed or deposited in any public office, or with any judicial or public officer, shall, without reference to the value of the record, paper, document, or proceeding so taken, pay a fine of not more than $2,000, or suffer imprisonment at hard labor, not more than 3 years, or both. Destroying a record, things like that. So here are some things that can be done. But even then, like I said, these people know conveyancing better than most people. You have to understand that they do know how things work. So generally speaking, you want to take care of and remedy or cure the defect in your paperwork generally before you go in trying to force things. So it's one thing if you have the deed. If you don't have the deed, there may be more discretion, but the other thing is you have to understand how things are actually handled. The body is considered real property. It's a real estate, actual land. What are we? Dust to dust. That's what men were taken. The bodies of men were taken from dust, and to the dust they shall return. So you have to be able to articulate certain things and stand on it. And if you are unsure, or you're antsy, or you're worried, or trying to just go about certain things and thinking it's all going to be always smooth, and it may not always be. And generally speaking, But I don't know how you were at the time. I don't know what the circumstances are, but like I said, I've had the people refuse plenty of times, but I've literally had to go other places and do certain things to avoid certain, because there are some counties that will refuse to file lawfully and legally executed things. But sometimes there might be slight changes in the wording, that the lands, tenements, and hereditaments of some name or someone, are conveyed, things like that. There's certain things like you just have to pay attention to. Making slight amendments sometimes allows you to go in and redo it. You might have to redo, But generally, if you did a trust before you did the warranty deed can be redone even if it has to be re-notarized. So, but adding something like that might be, like I said, you have a lot of people pulling discretion, but yeah. Because the alternative is literally, you still have to make sure everything's in a row and in line. But, if they still refuse to file certain things and all that, the only remedy that's really available is litigation to compel them to do certain things. So, take all the steps that you can beforehand to just cure the defect in the document, or rebut the presumption that whatever they said, XYZ, why they refused it in the first place. Because if you cure the defect and you do all that, and then they say, then what is the problem? And they try to give something else. Now it's just, But, a lot of times you cure whatever it is you're dealing with, things tend to change. Like I said, I would look at the wording of your warranty deed before I would go and start trying to force things. Like I said, lands, tenements, and hereditaments of said name might have to be alleged. Even if it just gives you another opportunity to go down there, like I said. There's been plenty of times when I've had to correct documents before they could be recorded. So, but yeah. But, clerks aren't always easy to deal with. Yeah, well, the name is considered the meets and bounds. Like I said, if you're, there's a possibility sometimes you may have to use it, like, if you have another address or another place somewhere else. I don't know. It just depends. If they're trying to harass you. Like I said, the body is considered portable land. So, wherever the property is situate, that's where the warranty deed can be filed. The other thing too is before you start really recording too many things, you want to make sure you get a fee schedule in there too. If they're giving you discretion like that, so that's something else that can be done. But there are workarounds for that, like I said. It just depends, like I said. You have to do everything properly. Yeah. Service a process to the court via what have you. In essence, yeah, you either face doing it somewhere else or depends on what's on it too. It heavily depends on what's on it. And there are other methods to deed property too, so it's not the worst thing in the world. But yeah. Interlocutory. Yeah. I mean, yeah, like I said, there's a lot of discretion, but part of it is having certain papers on the record, having certain statuses, doing certain things ahead of time, especially when dealing with the courts. Court is when it's like poker. That's when everybody shows hands. Maybe not every card at once if you're dealing with equity, but that's where the hands are shown. So, but yeah, there are methods around that. Yeah. Like I said, honestly, and it sounds crazy, but usually you get the most discretion when you have the least amount of papers filed as it is. Because these people are weak in the fact that they attack the weak or people in a vulnerable position. If you're not in a vulnerable position, generally they back off. So, like I said, you got to get standing. Make sure you do some of the paperwork ahead of time. There's other ways to convey property that they might not be aware of. That, there's less discretion, things like that. So, like I said, there's other ways to handle it. I'll go into that in private. Like, I don't want to cause a commotion, let's just say. But yeah, there's plenty of remedies. Like I said, equity looks to intent. Well, equity regards substance rather than form. So, equity looks past the form and looks at the true nature of the transaction. So, the way documents are worded, things like that. And that's what I can talk about. Y'all are in the land down under. I don't even know. I was watching a video about beach worms. 3-foot long worms that can paralyze somebody just from a one bite. No. Y'all got it. See, but the thing is, like I said, it's only until you have standing. If you do standing the right way and you handle and rebut the presumptions, a lot of that discretion goes out the window. Like I said, most people are dealing with certain things because they have not addressed the original presumptions. Presumption of death, presumption of incompetence, presumption of being a ward of the court, presumption of being under a curatorship or a conservatorship, the presumption, that someone else is acting on your behalf, things like that. So, yeah. Oh, I don't even want to know. Like I said, y'all live in the land down under. I don't even know what to say. Y'all got some things that'll kill you in one shot. Some animals that are deadly. I don't even know. You couldn't pay me enough to live in Australia. But as far as like what county recorders and other officials refuse to file certain things, generally you just have to do it a different way. And if it's something that's absolutely necessary, there are other ways to word it. But I can't really talk about everything like that in the public. Yeah. Like I said, Australia, UK, Canada, all these UK jurisdictions, you're still dealing with the SSKV Act. Maybe more directly than ever. If you're not able to record something, send it registered to yourself. That's considered a poor man's copyright. Once you've gotten that, then go try to record it. Or something like that. Get your standing in, the fee schedule, executor appointment, the notice of forgiveness and discharge of estate debts. Ordinance of estates, not allowing any capitalization or derivatives or hypothecations. Get those in there, get the standing in there so it's recorded in the register of deeds or the county or whatever the local recorder is over in that jurisdiction or that locale. And then you have to, like I said, you build up the standing bit by bit. So now you have the capacity to be able to handle certain matters. And then once you have the capacity, then they can't, there's less presumptions that they can allege against you. Because when you rebut the, incompetency and death and all these other things, now you have provable evidence that you can use. And then what's the real issue? Discrimination, discretion, things like that. Trust in place. So you have to be able to tackle it bit by bit. The only way you cut down a big tree is one hack at a time. It may not be done right away, but you sure got to start on cutting it down. Especially if it's a tree growing where it doesn't benefit you. Or it's a poisonous tree. From the fruit of the poisonous tree doctrine. So, things to be aware of. Like I said, don't be discouraged. I know I've been through all of it. I've had them lie and tell me in my face they can't record something when they're just being discretional, and I'm showing them the state statute that says they have to record it. Well, like I said, there's ways around it. If you know what you're doing, there's ways around it. The people they give the most amount of discretion to is people that are, generally, less experienced or newer to this. People that have papers and people that they can look up and search their own records, they don't harass, not to the same extent. So, like I said, tackle it bit by bit. Get your foundational stuff together, fee schedules, other things. And like I said, for conveying property, there's more than one way to do it. So don't be dismayed or things like that. But, yeah, I know it's frustrating, 100%. But whatever you do, if you give up, it's for sure never going to happen. At least if you find another way, it can still be done. Sounds good, Spence. So, yeah, but believe me, I've had some different offices absolutely refuse to file anything under my name. So, like I said, I do understand what goes on. But like I said, where there's a right, there's a remedy. See, and that's the best place to start. Because even when I was doing my rescission paperwork for certain contracts, and withdrawing my consent and my signature, you have to look at the original contracts and what was even conveyed. If you're not looking back to the original, agreements or terms or, whatever, you're not even addressing the root cause or root issue. So, for statutory identifications and contracts and statuses, it's the state statutes or the, whatever applicable, federal or state statutes or, municipal things. That's what it, is handling that. With other things, it's, generally you have to, or the contracts, it's with contracts, the original terms of the instrument, the agreement, the covenant, things like that. So you have to go look at the original language, see what was done, rebut those presumptions in writing. There's a method to the deed or the document title. There's things that can be done, estoppels at law, rescission, withdrawal. With deeds and certain instruments and applications that are controlling, may not be able to rescind them. You might have to just recover them, which is why you have to go to court for certain things. But with contracts that you're able to get rid of, that they, notice, there's certain things, like I said, that can be done. But you always have to go back to the origin. Otherwise, you'll never actually deal with the root problem. It'll only be whatever's on top. And you won't really get anywhere, to be honest. That's why signatures can be granted and signatures can be rescinded. Usually due to some, exigent circumstances, either fraud, duress, coercion, etc. But that can be done nonetheless. But yeah, there's, like I said, there's plenty of things that you can do. So, and another thing too is knowing how to properly create documents. When you create documents, you have a lot more leverage and leeway. You have to understand more. Mind you, there is a higher knowledge base that you have to have. But creating your own documents is essentially, you have to be able to understand writing. If you can write a thesis, or you can present like a research paper or something in that essence, and answer different questions with different points and authorities, you can generally write a document. There's some things that may not always convert in the same way or apply across, cross doctrine, or cross between research papers and legal papers, but there's a lot of things that correlate. So making sure that you understand the basics of contracts and the basics of what is going on or how things are operating. 12 presumptions may be resolved, but you are giving wrong legitimation, correct? Well, but the thing is, it's like, if you don't rebut the presumptions, you won't have any standing. You won't be able to get anything done. You have to rebut the presumptions. If you don't rebut the presumptions, you'll be dealing with an uphill battle. So, like I said, you have to tackle the presumptions of court, because presumption of law is not actual law. However, there are a lot of courts that treat them as such. So you have to step in and correct those. If you don't, you are assenting or consenting to them. And even if by acquiescence. So, implied assent versus express dissent. Something to be aware of. So, but yeah, when you create documents and in your own language and you have understanding and scienter, knowing, in Latin, knowledge or awareness to be able to create these things, there's a lot more power that's conveyed, especially when they see it's coming directly from you. So that is something that, you have to get better at as you go studying different documents. But yeah, this is why you have to be able to understand things for yourself as well. Because even in trust, you have to be able to write at your own meeting minutes. Generally, there's templates out there, but you have to know the elements, the format, the procedure, what to look out for, things like that. So even in the administration of an express trust, there are papers that you have to create or, at least draft up and amend from prior templates and know what to look for under, especially under express trust. If you know how to run a nonprofit, generally speaking, you know how to run an express trust for the most part, other than the private stuff. That's interesting. What is Article 61 again? I'm not that familiar with the Magna Carta. Yes, but like I said, the SESKV Act is still in effect until you rebut it. They're considered secret trusts for a reason. Otherwise, you wouldn't be able to probate an estate. See, this is a writ of execution, though. You have to know how to compel that. Yeah, the fraud vitiates everything, but you have to understand how this is even effectuated. Like I said, it has said that the barons had the standing to be able to seize the property. If you're not a baron, then this generally does not apply. So, like I said, there's things there that prevent people from using certain provisions. You have to understand the standing and how the provisions are affected. You're right, but they're not going to admit it, and like I said, due to presumption of law. Well, like I said, I've probated my estate. So I've gone through the probate courts, in the county I was born in, and I probated my estate. It's quite simple. The certificate of live birth is a death certificate. The will is presented, the will of the testator, or the testator is just a fictional entity. So what was the living man's real intent? So, the natural person was in his will to appoint the living man the executor. So, and as a result, the court have been acknowledged that the first, middle, last, the Romanization is a decedent. This is why in the military, school, hospital records, they're all surname first, given name last. Given names, plural, last. It's the same system set up just about everywhere on earth. So you just got to know how to administer it properly. Once you know how to administer it, it's easy. You're looking at both sides of the mirror. But you got to stop claiming to be a person before you do that. Doesn't matter whether you only assume to have just the first or the given names, the first and middle, you have to know and understand how they are put together and why they are put together. The surname is where the property, shows, or where you arose from, and it shows the proper order. So you have to be able to articulate certain things in the courts. Otherwise, you'll be, like I said, you won't address the real issue, and they'll know you're still incompetent. So we were all incompetent at one point. The question is whether you stay that way. But if you choose to ignore it, that's ignorance. And there's a certain ignorance that can't be pardoned because you chose it. Yeah, but here's the other thing about the Magna Carta too. Like, where's the jury of our peers? If everyone is presumed dead and everybody's considered a person, whether natural or artificial, where is a jury of your peers of living men and women that has standing and recognition, that's actually claimed their accounts and minor estates? That's the main issue. If you don't have that particular means, it doesn't really mean anything. Because why would you want a jury of someone, a whole bunch of a jury of someone that's not your peers? Or citizens. Citizens are businesses. They've always been businesses. I don't know why people don't, most people don't understand that. The national is the one owing permanent allegiance to a state. What is a state? An estate. A status. A state of being. An entity. A person. Right, but where are you going to find a jury that's equal to you in status as a living man or woman? They don't have them. All they have is jury of persons. If you're not a person, how can you have a jury of your peers? It doesn't make sense. No. Why would you want a jury of a whole bunch of citizens, which are just nothing but incorporated entities into a larger corporation? They can't represent the living. Nor can they speak for the living. So why would you want a jury full of them? This is why matters have to be handled privately. In chambers, in camera, under seal, with a protective order, in the private side of the court. Living men and women can't be seen in commercial courts in the public. Commercial courts handle commercial matters. And commercial matters are public now that corporations run the world. So, like I said, you have to be aware of how things operate. Yes, the Magna Carta is in effect. Yes, these things are in effect. But the Magna Carta and other things, even the Declaration of the Rights of Man, the French Declaration, those are all dealing with men and women. It wasn't talking about anything with persons or humans. I know what you're talking about, RIP, but that's not how things operate. I'm just telling you right now. You're dealing with, bodies of persons. You're not a person. You have a person. You have to know the difference. Right. Commercial is public. Foreign is private. Yes. So, but yeah. In chambers is the only place to handle private equity. Look, let's just put it this way, RIP. If you're not controlling that capital letter name and that fictitious person, and you are the person, you're no better than wearing the mask, and the mask is controlling you. All they see is the mask, and all they see is the character. They know that you're acting and an actor, but they don't care who you are. As long as you pretend to be someone you're not, they'll treat you like it. You have to handle things according to their true intent. But if you don't know who you are, you don't know how to spell your name or arrange it via the mode and means, it makes no difference. You have to understand how these things operate. There's two sides of the court, public and private. You have to put a notice in the public, and you have to keep your substance or your statements in private. This is why under the supplemental rules of admiralty, they have the notice of interest and statement of interest. The statement of interests are your private evidence and your claims in private. Your notice is a kind of a colorable notice that just lets people know that something is there. This is why you have the difference between the two. They go on simultaneously in public and private in the court to protect confidentiality, not to breach your own trust, and yet to preserve intellectual property or trade secrets. And these different terms can be researched for different jurisdictions. They call them slightly different things, but they're the same process. Intellectual property, trade secrets, confidential commercial information. They're just, like I said, different jurisdictions have different ways to say it. Even different states, a lot of times, have different ways to put it. But, generally they port to the same things. So, but yeah, like I said, look up trade secrets and, confidential filings made under sealed court records. Like I said, half of the discretion that people get, if not most of it, is because they're putting it all in the public side of the court. They don't know how to operate both sides. Right, I'm aware of that. That's why the Roman Catholic Church is they never fell. And that's all the more reason to rebut the Roman presumptions. There's certain things that have to be done in public. There's certain things that have to be done in private. Yeah, most countries are under some type of military occupation and foreign administration. And it's just the way things are right now. It's why you have corporations running governments, or governments, corporations presumed to be the government. But you have to know how and when it arose and how to articulate it and everything from there. If you can't articulate it, that's when you get these labels, these unfavorable labels that they try to apply to certain people attempting to correct their status. So, yeah, like I said, there's a lot to learn. But any other questions? Like I said, do my best to answer them. Yeah, you know what I'm talking about. Yeah. Miss Owl, that is correct. That's what they try to label people. Like I said, for most people I hate to say this, I'm not trying to attack or come at anyone, but most people's processes, especially foundational, are not sufficient. Secured party creditors and things like that, and accepted for value, and certain things. I'm not talking about conditional acceptances, that's different. But certain things, just only doing an administrative process and getting affidavits and getting them into default and not having any responses and even a notary presentment, that's cool. All that is prima facie evidence. You still need declaratory judgment, which means you have to go to court. All roads lead to court. So you have to be able to, stand on certain things. You do acknowledgments, name corrections through court-ordered name change, from all caps to upper and lower. Half of the discretion people are getting is because they're not taking the proper steps in equity. It's considered a deed poll or a bill of reviver when you do the name change properly. So, and that ports over for a lot of different jurisdictions. Like I said, I've done the long way. That's why I can say certain things. If I can spare somebody some time and trouble and just do it the right way, just do it the right way. Because when you do it the right way, you end up reducing your national debt. Like when this is all said and done. And they don't actually, it doesn't hurt the economy. You just have a lot of people that are trying to stand on you and stand on your neck. So the only one that's going to allow you that to happen is you. Or, you can change and correct the situation. So you just gotta, like I said, look up Tammy Pepperman. Tammy Pepperman's stuff applies to almost every UK jurisdiction out there. Look up, Boris was, American, but it does make sense. He talked about a lot of certain things, especially in regards to the Treasury and Exchequer and how people went debt-free because they, Treasury debts versus private debts, things like that. Things like that. Christian Walters was a master of trust. You have to be able to operate out of trust. Like I said, any places where there's common law due to the UK jurisdictions, there are ways to go about creating private, foreign, irrevocable, express trusts. The languaging may need to be changed to port over to certain things. Validly recognize things under maybe the Magna Carta or other documents, things like that. But the trust has the settler has the ability to choose the law form of the trust. That's under the Hague Convention on Trust and their their recognition. It was 1985, Article 6. So, like I said, it's up to the intent and purpose of the grantor, the settler of the trust, to determine, what law form is going to govern the administration of a trust. So, it may not be the federal Constitution or the original Constitution or even the Declaration of Independence, but there are applicable older treaties that go, Magna Carta, things like that, that go, further back, that allow you to establish certain things. So that's what I would research. It's not that hard to actually create your own trust, just from scratch. But you have to know what provisions to put in there, what you're doing it under, and how a trust is recognized. You have to research case precedent, things like that. And that's what really allows you to do certain things. It would be in the original trust instruments. Usually the declaration, you'd have to combine a declaration with some sort of conveyance or transfer of property, usually some type of deed, especially when it's express or irrevocable. But, generally it's in the original trust instruments, and that would be some type of declaration most of the time. Or contract, depending on the parties. Depends on how you set it up. But just know that revocable trusts aren't sufficient. You have to have an express, irrevocable trust. And that goes for most places. And generally, you want that foreign, so that they can't just reach inside and grab it and administer the trust for you. Absolutely, Carissa. Give me one moment. I got to take care of one thing real quick. I'm going to keep everything going. But like I said, I'll come back to these questions in just a second. I apologize. I'm back. I don't know. No, most of those are cars. There's some loud cars over here. But, I mean, yeah. So, realistically, like, you have to know, like, Gilbert's Laws, summaries on the, the law of trust is an excellent resource. There are other resources available for, especially with dealing with trusts. I would look up some, like, I would read those and those that are relevant to your locale and your area and your jurisdiction, whatever country you're dealing with right now. Especially when you're creating any type of trust. But it can be a 1-page document, it can be a 1,200-page document. It just depends on what you need it for. So it's, yeah. A lot of times it's easier not to reinvent the wheel, to look at art trusts that are already, well established and well put together, to kind of get a frame of reference how to even do it in the first place. It's generally how I've done a lot of documents. You look to see what has already been done, what has already gone through and works, and you take the essential elements. You see, the brevity or the how it was made, and you either duplicate it or make it applicable for your situation, things like that. So that's what can be done. And yeah. But most of the time, it's, like I said, there's 4 different elements for a trust. There's intent, the settler's intent, the settler's purpose for the trust, the specific parties and specific res. And then there's one method of formation. So, it's either appointment, contract, transfer, or I believe, is it assignment? No. Appointment, contract, transfer, declaration. There we go. Those are the 4 methods. So delivery and bearer form would be a form of transfer. Assignment of interest would be another form. Assignment of wages, things like that. Just depends on what you're doing it for. So but the same way, once you understand the language and these books, it better helps you to be able to form certain trusts. So, or documents, things like that. There's certain other books too, One Man Out, Redemption Manual, things like that. Like I said, not all the methods are applicable to certain things. Some of them work, some of them don't. But they tell you what's worked in the past, and you pay attention to how things have changed since then. Generally, you're able to figure out what you need to do. So, I hope that helps. Any other questions? if you don't have the original documents, I mean, the thing to remember is, like, there's things you can do post-transfer, like alleging a mistake, doing an administrative process to, properly challenge who the original parties are. That would be a time to use an administrative process, original presentment, notice of fault and opportunity to cure, and then default and dishonor. That would be a time to use that. Now that would be what you would use that for, is to, or were you the original grantor? If I pledged this collateral and this property was conveyed to me via this particular deed, as everything is prepaid due to XYZ bankruptcy for national bankruptcy, then, on this account, then, as I'm, am I not the original grantor? Since this property was conveyed to me, and then I re-pledged it. But you can't give what you don't have, which is also a maxim. So if it was not mine, how could I re-pledge it? Things like that. Yeah, like I said, the original res is the signature. That's what backed the mortgage by any type of collateral. So you have to go in and, re-express that. Like I said, doing certain presentments, doing certain things, grantor, on the mailing and, the papers, by grantor, by beneficiary, things like that. So you have to re-express it. Even if it's down to the very postal mailing records, notary, certain things like that. Mail records are generally considered trusts because you have sender, carrier, and recipient. Grantor, trustee, beneficiary. So you have to properly know the rule of signatures, how to properly express a trust, even with the rules of signatures. When you send something, it's by grantor. The recipient, upon the mail for a return receipt, would be the beneficiary. And that's how you construe a trust also. It's not just with mail, it's with all, a wide variety of things. It's always been that way. Trusts are generally three-party relationships. Can be two, but there's still three roles. So you have to be aware of that. And like I said, I'm not trying to beat anyone down. I need to impress upon the importance of certain things. So a lot of this is particular and very peculiar and unique. It is a trust. It's a bank. It's the original bank. Every postal record is a trust. That's why I keep talking about it so much, because there's so many trusts. Until you start administering and reconstruing and correcting the mistakes you make as grantor, they're going to keep on reconstruing the trust in their favor, especially if you aren't expressing your intent and purpose for the trust. So you have to, express that. I didn't come up with that. I found that one out from others, but I understand how it works. I do know that. But like I said, I didn't come up with this stuff. There were plenty before me that put in the time and years and hard work and dedication to be able to discover certain things like that. All I'm doing is knowing how to use it. That's the only difference. But that's why you need to be able to know how to use certified mail, return receipt, registered mail, return receipt, express mail, overnighting certain things, knowing what the purpose is behind them, when to use them, how to create evidence of trust, things like that. So, whatever place you're in, in the States, it's the certified mail green card or registered mail green card. In other places, usually the same thing, but it might have a slightly different form or something like that. But generally, they'll have the same forms. Might be slightly different for the jurisdiction, but that might be it. So, but yeah, any other questions? Floor is open. Like I said, it's not just what you do, it's how you do it. This is why you don't shake babies on their heads. And when you present certain things, it has to be done in a certain way. But I wouldn't wish half the things I've gone through in the courts upon someone else. So if I can spare somebody the trouble, I will. Any other questions? Any other comments? Things you curious about in law and equity? Any thoughts? Yeah. The fool has to smart for it. The fool is a smart man because he always has to hurt for it. A wise man looks to someone else's hurts and learns from that and avoids the hurt. And avoids the smart. That's the difference between foolishness and wisdom. But like I said, any questions, like I said, floor is open. Let me know. Anything y'all are curious about in the courts, in equity, contracts? Thank you, Roots. I'm grateful. Like I said, I know what it's like to be anxious and, not have a freaking clue and still have to deal with everything all at once. So it was like 20-foot tall tsunami waves just crashing. So, like I said, I'm not trying to paywall anything or do certain things. Like I said, it's just, yeah. I want everybody to understand it. Because if more people understood trust law, we wouldn't be in half the mess that we're in. And it makes things so much easier than when you have so many greedy actors. Yeah. Gaslighting doesn't do anything, it just deters people that are already on the right path. That's why people do it. Because they either can't admit to the truth, or it doesn't benefit them, or a combination of the two. So that's why it even happens in the first place. But like I said, any questions, like I said, let me know. Probably go another like 15, 20 minutes, something like that. Like I said, any questions, anything you're curious about, there's plenty of stuff in law and equity. I don't know everything, but I know some stuff. Like I said, any questions, put it in the chat. Like I said, the biggest amount of all these freedoms that people are looking for, they're all tied into, knowing and understanding how to move and how to operate the right way. That's really how, what you have to know how to do. Because there's a right way and there's a wrong way. But the right way involves clean hands, which is why you have to do everything the right way. I get that. Yeah. Like I said, maintaining, diligent records. Anytime you make a deed or a document, you make an original copy for yourself. Properly putting disclaimers in there for notaries, things like that, because the notary is a contract with the state, and it's things, so there's plenty of, properly, detailing all of your intent and purpose, being concise and very, to the point, handling everything point by point, things like that. Maintaining diligent records, separate accounting for each thing. Every matter is its own trust or case. So, yep. But yeah, any questions, put them in the chat. Sheesh. But yeah. But yeah, a good movie to watch out is Tenet, Mr. Nobody, Laundromat. Laundromat was good. What else? Shoot. What other movies talk about it? There's so many movies that talk about this type of thing. To be honest, I'm not entirely sure, Carissa. I'm not entirely sure. Open to suggestions. Got a couple things that I'm probably going to talk about. One is probably overcoming recording denials and things like that. Dealing with discretion, especially at first. The documents that kind of help prevent that, ways around that, things like that. It's probably going to be a few different things, to be honest with you. It's probably not just going to be a huge one topic thing, but yeah, I mean, like I said, I'm open to suggestions, Carissa, so let me know. Yo, the way that you put that was so funny. Oh man. Hey yo, nah, that's the last resort. And I don't even want to go that far. I know how, but I prefer the amicable method better. Oh yeah, that's true. Alright, bet. I can do something along that lines. Creating court documents. I'm trying to think what would be a simple method. I can do that. I can do that. Wearing jumpsuits, I don't know. Oh man, that's crazy. Yeah, no, I can do that. I mean, that's fair. It's not easy for especially when you're starting out at first, but that is something I can do. So you said that, and yeah, and then overcoming presumptions. So yeah, I'll remember that. Presumptions and dealing with refusals, things like that. Yeah. That we can do. That'll give us an opportunity to do certain things tomorrow on the call. Yep. Like I said, you want to be in there and you're not in the class, it's a private class, so I can't go over everything in the public. If I did, the system might not be around and my channel might be blocked. So let me know if you're not in the class and you want to be in the class already. You got to. If you don't, you go mad. You either laugh or cry to get through this sometimes. I've done both. Believe me. Oh shoot. I've done both, definitely. Yeah, like I said, when I started this, I got some pretty good information, really the real stuff from the start, and then I already had a decent amount of English experience. I had probably just under thesis level, paper writing and experience and stuff like that. I've already written research papers. I was fairly good at it, and I knew how to formulate a thesis and certain arguments and certain things like that. Because at the time, I guess I was a little argumentative at times, but that generally, if you've had that level of English experience, you can form a thesis, you can form a argument on paper. I mean, that's your biggest experience that can translate to writing legal documents, because it has to be able to rebut the presumptions or go against and shift the burden of proof. and you have to address the main issues at their root causes. So you have to treat those like their questions, and then, you know, answer them with points and authorities that kind of align with what you're talking about. So but yeah, like I said, there's ways to get around things, because, yeah, most people aren't aware. Like, a lot of times they're only looking for certain things, trying to be discretional when and abuse discretion when they really don't have the power to. And there's, you know, like I said, there's always a workaround, a remedy, some way to get it done. It's got to be done. There's a way to get it done. But yeah, any other questions? Anything else people want to cover or I'm curious about? Absolutely, Carissa. Absolutely. Alright, well, I'll go a few more minutes. Any last questions for the night? Any last questions? Well, so we'll have another exclusive equity live discussion next Thursday, 7 p.m. Eastern Standard Time. Another live on YouTube. Tomorrow, like I said, we'll be covering basically how to create just certain types of documents, overcoming rejections from recording, things like that. Generally that's what we're going to cover tomorrow. Probably cover some other things as well. The Friday classes are at 7 p.m. Eastern as well. And, that'll be on Zoom for the members of the Private Equity Weekly Workshop. If you're not in it and you'd like to be, send me an email. My email is in just about, I think, every one of my videos at this point in the description. So, you can message me there. If you'd like to set up a consultation, I have my website. I'll put that in the description of this video as well. It's on my last one as well, so you can check it out there. If you need a trust setup, I do provide, assist with that as well. So, like I said, fill out my contact form on my site and let me know. But other than that, any other questions before we wrap it up for the night? Alright, well, if that's all, I'll catch you on the next one. All praises to the Most High. This is B with 2B Fruitful Training Group. I'll see you on the next one. Good night, y'all.